Okay, I believe we are live here. Good afternoon, everyone. My name is Jeremy Herman. I am an employment lawyer at Samfiru Tumarkin LLP. I'm located in Toronto, Ontario, and we do multiple of these live Q&A sessions every week across Ontario, British Columbia, and Alberta. And the goal is so that your workplace questions can be answered and hopefully rectified. And so that is what I'm here to do today. I'm here to answer your questions live. Please don't be shy. Ask your questions, and I will do my best to answer them. Before we go on with some of your questions, I just wanted to talk about a hot topic that's going on right now. And if you joined my last session, you'll remember that I spoke about terminations from Shopify. And just to remind everyone, Shopify is a company that terminated 10% of its workforce. And they thought that they were going to transition smoothly into the e-commerce world, and they realized that that was not successful. And as a result, they laid off 10% of their workers. And what they said as part of their announcement was that they were going to offer 16 weeks of severance pay plus one additional week for every year that the employee worked at the company. And I discussed in my last session how this is a one-size-fits-all severance package, and there are issues with that. Now, recently, another big tech company called Clearco laid off 25% rather, of their workers at the end of July of this year. And just recently, they announced that they are terminating another 60 employees. And unlike Shopify, Clearco is not, as far as I know, adopting this one-size-fits-all severance package model. So they're not saying that for anyone terminated, you're owed the exact same thing upon termination. And that is unlike Shopify. But either way, I could assure you that it is most likely the case that Clearco as well is offering severance packages that are inadequate. And so you should contact us if you have been terminated from Clearco, from Shopify, from another tech company, or really from any other employer. And if you were offered a severance package, you should ensure that you contact us at help@employmentlawyer.ca, and we will review that severance package for you. We will determine whether it is adequate, whether it is reasonable. And if it is not, then we will assist you to the best of our ability of getting you the severance package that you deserve. Okay, so I'm going to start with the questions. I have a question on YouTube from Anna. Anna says, I'm finishing maternity leave, still my 900 hours of new hire probation, and may get laid off due to vaccine mandate upon return to work. Would I be entitled to severance pay? So there's a lot going on here, Anna. What I think you're asking is, even though you are within your probationary period, then are you entitled to severance pay if you are terminated as a result of a vaccine mandate? And the answer to that generally would be yes. If you are terminated as a result of a vaccine mandate, you are most likely entitled to a severance package. We've helped many individuals in that position get the severance packages that they deserve. So please contact us if you are in that position. And there might be some hurdles to overcome with respect to your probationary period, but it is certainly still possible to get you a severance package. And so please, Anna, don't hesitate to contact us. Again, you can contact us at help@employmentlawyer.ca, and you can check out our website as well at www.employmentlawyer.ca. We have tons of resources, blogs, interviews on various media platforms that you can find on our website on a variety of employment law topics. So please don't hesitate to check that out. Okay, And if you have a follow-up, by the way, then feel free to ask that follow-up question. All right, and I have another question from Randy on Facebook. And Randy says, when you work in an industry for 35 years with toxic chemicals, is it reasonable to expect compensation for the inevitable cancer? And then Randy says, I have polycythemia vera, and I apologize if I didn't pronounce that correctly. And so, Randy, this is, I understand why you think this might be an employment law issue. It isn't necessarily one. It could be from the perspective of a health and safety issue, and you have rights to work in a safe environment under the legislation called the Occupational Health and Safety Act. But this could also be a different type of legal issue that we would call a tort issue. And so if you have evidence that you have contracted this disease as a result of working with toxic chemicals, then you should definitely contact us. We'll learn more about your situation, and we will gather the information we need, and we'll let you know whether we can assist you with that. Okay. And another question on Facebook from Tim. I'm happy to see all the questions rolling in here. So Tim says, my employer put me on a layoff at the end of July and said I would be called back before the end of August. I've just been notified that my position has been posted online and have not heard back about my return. What should I do about this? If I take another job, is it considered quitting? Okay, Tim. So if your employer put you on a layoff, you can treat that layoff as what we call a constructive termination. So what that means is your employer did not literally terminate you. They did not say you're being terminated. Instead, they said you're being put on a layoff. That's temporary. And we've assisted many people. I've been working on some of those cases even today before this session, where employees have been put on temporary layoffs, and you can treat that as a termination. It will depend on what your employment agreement says. If your employment agreement says you're allowed to be put on temporary layoffs, then that will be problematic for you. But so long as your employment agreement doesn't say that, and so long as you didn't agree to these kinds of layoffs in the past, and there's no history of them, then you will likely be owed a severance package as a result. So please contact us to learn more about that. And if they posted your position online, that could be problematic. If there's only one position of that nature in the company, and you think that they're literally trying to replace you, that's certainly problematic. They do have a duty to reinstate you. So please contact us. Again, we'll learn more about your situation, and there definitely might be a route for you to claim constructive dismissal as a result of this layoff. Now, just lastly, Tim, I want to talk about the last piece of your question, which is that what happens if you take another job? And so if you take another job, it's not necessarily considered quitting, but you should be cautious about that. Your employer can certainly construe it as you resigning or quitting as a result of you taking another position. So what I would do is ensure that if you want to proceed with the route of constructive termination and try to get a severance package, that you start with that process beforehand, and then we can provide you advice as to whether you should take another job and whether that could impact your severance pay. But just note that it might, and you should be cautious and ensure that you contact us to learn more about that. Okay. So Anna, looks like Anna has a follow-up question, and she says, if I have two employers and get let go from my primary employer, would I be entitled to severance pay? It's a great question, Anna. And typically, when you are terminated, your employer has a duty to provide you with a severance package. As the employee, you have a duty to look for new work. We call that a duty of mitigation. And essentially what it means is that you have to do your best to try to find another position, to try to reduce the damages or the compensation that your employer owes you. Now, if you do have another job, then it doesn't mean you're not entitled to severance pay, but your severance pay could be reduced based on the income you receive from your other job. Now, that will also depend, Anna, on whether your other job was one that you had previously prior to the termination from your other employer, or whether this other job is new. If the job is new, it can certainly be used to offset the severance pay that you're owed. If you've had this other job for a long time and you're terminated from the first job, then it may not impact your severance pay. That's a great question, though. Okay. So we have an email question from Diana. My company has just notified all sales agents that we will be getting half of the sales commissions that we used to get. Can they just change this without notice? It means I will be earning a lot less. I'm thinking of changing jobs because of this. Okay, Diana. So before I was speaking about with Tim a constructive dismissal or constructive termination, and you can use those words interchangeably. And so if you are getting reduced pay or reduced commissions, that certainly can be considered a constructive termination. That is a classic case of constructive termination. And so you are likely owed a severance package. You can treat that as a dismissal. It will depend on the reduction in pay. There's no exact amount that it has to be a certain reduction of a very exact formula in order for it to be considered a constructive dismissal. But it certainly can't be nominal. It has to be, we like to say, within the 15% range or more. That kind of reduction in pay certainly could lead to a constructive dismissal case. If you change jobs, though, Diana, and you don't claim constructive dismissal, then that would be considered resigning from your employment, and you wouldn't be owed a severance package then. So before you take that step of changing jobs, certainly contact us. We can set up a consultation and we can learn more about your situation, and I could advise you further. One of my colleagues can advise you further. Again, you can contact us, as you see on the screen, at employmentlawyer.ca, or email us at help@employmentlawyer.ca. I think at this point as well, I should add that we have a very amazing, nifty tool called the Severance Pay Calculator. And you can find that at pocketemploymentlawyer.ca. And so what that tool does is it's a very simple, easy to use tool. It asks you basic questions about your employment situation, and it will advise what kind of severance package you're looking at. Now, it's important that you book a consultation and contact us, because there are other factors involved beyond what the severance pay calculator knows. But it's certainly a great tool, and it will help you get a sense of, based on your age, how long you've worked at the company, how much you were earning, what position you were in, what kind of compensation you would be owed. And you very well could be owed as much as 24 months or 2 years of severance pay. And so check out that Pocket Employment Lawyer to get a sense of what kind of compensation you're looking at based on your particular circumstances. Again, pocketemploymentlawyer.ca, as you see on the screen. Okay, we'll move on. I see a question from Stephanie. Stephanie, this is a bit of a lengthy question here. Since I have other questions, I don't want to summarize. Instead, I would ask that you please contact us, and we will ensure that we take a look at your situation And it seems to be that it's a very particular situation with possibly some private confidential pieces here as well. So please contact us at help@employmentlawyer.ca, Stephanie, and either myself or someone from my team will assess your question and ensure that you get the answer you're looking for. Okay, I have a question from Harold. Okay, Harold asks, is there such a thing as quietly firing, where the employer continues to take away job functions to the point where one is doing almost nothing, and they terminate you due to reorganization? A great question, Harold, and I'm actually very pleased that you raised it, because it was something that I had on my agenda to speak about today. And so there is something called quiet firing. I want to start off by actually talking about something called quiet quitting, or quietly quitting. And then I'll move on to quietly firing, if that's okay, Harold. And so quiet quitting, it's a new trend. It's essentially where employees do the bare minimum to ensure that they have some work-life balance. And so they do whatever they need to do to maintain their job without actually resigning. And so, first of all, don't get caught off guard by the fact that it's called quietly quitting. This phenomenon is not actually quitting from your position. You haven't resigned, but it just means that you're doing, like I said, exactly what's set out in your job description. You don't take on extra assignments. You don't try to involve yourself in the life at the company any more than you have to. And this is quiet quitting. And like I said, it's a new phenomenon. We're seeing it. It's becoming more and more common, especially with this generation of workers. And we're seeing a phenomenon where this generation only wants to do what they have to do in order to maintain their job. Maybe they have other job prospects out there and they want to check those out, but they don't want to actually resign from their employment. And also work-life balance is becoming more and more important to people. And so this notion of quietly quitting is becoming more and more popular. And I should add that we have brand new legislation about rights to disconnect. And that means that your employer cannot take any disciplinary action against you if you do not work outside of your regular job hours, if you decide not to check your emails, etc. You are protected in that event. And this goes hand in hand with this notion of quietly quitting. And what you should know, if you're considering quietly quitting, or you're already in this kind of situation, that first of all, you cannot be penalized as a result. If you are fulfilling the job duties that you have to do for your job, then your employer cannot penalize you for doing what you're set out to do. Having said that, though, you do have to fulfill those duties of your position. If it transitions a little bit into not doing what is expected of you, that could be problematic as well. So it's important that I flag that. And if you do face disciplinary action as a result of quietly quitting, or you are terminated as a result of that, again, please ensure that you contact us, and we will help you determine whether that termination was proper, and whether you were offered the proper compensation upon termination. I should add, though, that quietly quitting is not illegal. Terminating you is also not illegal. Your employer, generally speaking, unless it's for a reason that has to do with discrimination, they can terminate you. But they can't not offer you what you're owed upon termination, even if it was as a result of quietly quitting. Now, just lastly, I want to talk now about quietly firing. And this is a notion similar to what Harold brought up. And that is kind of on the flip side of quietly quitting. And it's where your employer puts you in a situation where they strip you of duties, or they just generally make your work environment toxic or unbearable for you. And the goal there would be, from your employer's perspective, to get you to quit. And so in a way, they're firing you, they're quietly firing you by putting you in a difficult situation, or stripping you of your duties so that you quit. And then as a result, if you quit, you are not owed a severance package. And so if you are in that situation, again, please ensure you contact us at help@employmentlawyer.ca. I just had a similar case to this where I had a consultation with somebody and their environment was toxic. There was a demotion to their duties, and they felt as though their employer was trying to get them to quit. And I coached that individual through that process. They ended up getting terminated without cause, which is actually what the employee wanted. And they were then offered a severance package. So try, if you can, if you're in this situation, don't resign. You'll strip yourself of the right to a severance package if you resign. If it's completely an unbearable work environment for you, then we're not going to tell you to stick it out if it's taking a toll on your mental health. But it's always best to seek that legal advice in advance if you're in a situation of either quietly quitting or if your employer is quietly firing you. Okay, I will now move on with more questions. We have a bunch here. So we have one from Carrie. And Carrie says, if I'm asking for a workplace accommodation for medical reasons, can my employer dictate what am I allowed to do outside of working hours? No. So generally, Carrie, they're not allowed to do that. What you do outside of working hours is your own business. Now, having said that, if this became a legal case, if your employer does have evidence that you, however they obtained it, they might obtain it illegally, your employer. But if they've obtained evidence legally that you are doing things that are absolutely contrary to the accommodations you need, so as to say that you do not have whatever medical issue that you're facing, then that could be problematic for you. So they cannot dictate what you do and what you can't do. However, if they become aware of certain things that you are doing that doesn't seem to line up with the accommodation they're providing, then that could be a problem. And so ensure that you contact us if you're in a situation where you feel like your employer is encroaching upon your private life. It probably is problematic. And you can contact us again at help@employmentlawyer.ca or go to our website at employmentlawyer.ca. JR asks, how does one go about determining the current status of an unemployment claim investigation, whether or not it is open and active for someone who is unemployed and has already contacted the DOL? JR, I'm not 100% sure what you're asking here. If you're talking about employment insurance, I'm not sure if you're talking about employment insurance, that kind of claim, or if you're talking about a Ministry of Labor claim. If you're talking about a Ministry of Labor claim, then you should be able to contact the Ministry of Labor to determine the status of their investigation. I know it does take some time. So if you want to clarify JR in the chat, then you can do so, and hopefully I can better assist you with an answer. But for now, I'll move on to Nancy. Nancy says, I am a superintendent, maybe is what you mean to say. I'm not sure what you mean to write there, Nancy. And I live in a free unit. The building was sold in February to a new owner. There's going to be a new property manager. Just was wondering, due to my years, start over for doing this job for the past 15 years plus. So I believe I know what you're asking, Nancy. So if the company is sold, if there's a sale of the company, it will depend on the type of sale of the company as to whether they have to take you on as an employee, the new owner of the company. If you are taken on as a new employee of the new company, then your seniority, which I believe is what you're asking about, should maintain at the 15-year mark. There are situations, I've dealt with many of them, where new employers in this situation will try to get the employee to sign a new employment agreement. That new employment agreement can say a whole host of things, one of which could be that you do not maintain your seniority. That would be problematic. The employment agreement, and this goes for anyone who is being asked to sign a new employment agreement. It could say things that talk about termination and what you're owed upon termination. That is a very important term of your employment agreement. And it's very important you understand that term. It can talk about what happens if you're laid off by the company, if that's illegal or not, what kind of confidentiality you have to maintain, whether you're allowed to compete or not, whether you're allowed to solicit other employees or workers of the company. So these are all key terms of employment agreements. If you're being asked to sign a new one, Nancy, or anyone else out there, you want to get that agreement reviewed. I can't emphasize how important that is, that you ensure that an employment lawyer reviews that employment agreement. It could strip you of your seniority. It could dictate that you're not owed what you're owed upon termination, and that could be legal at the end of the day if you sign that agreement and don't understand it. So please ensure that you contact us at employmentlawyer.ca, and we can review any employment agreements you have. I do that on a day-to-day basis. I've done some today. I'm going to do some after this live session, most likely. And so we're very equipped at doing that. Okay, we have a few more minutes. So Jay says, similar to an earlier question, if they lay you off and you don't get recalled, not due to replacement, but due to the elimination of the position, how should that be treated? Jay, so that is a termination. If they are not reinstating you after a certain period of time, if you receive benefits from the company, it's 13 weeks. If they don't reinstate you after a 13-week period, then that is a termination. It's not a constructive termination, it's an outright termination under our provincial legislation. And so you would be owed a severance package, regardless of whether they're replacing you, not replacing you, eliminating the position. So it sounds like you might be owed a severance package, Jay. And Jay, you're noting that you're in BC. That would apply in BC as well. Each legislation says something different about the amount of time, but ultimately, if you're not reinstated, it's a termination and you're owed a severance package. Okay, let me see if I can get to Paul's question. So Paul says, I have an employee who traveled outside of province on vacation and told my company that he had contracted COVID and needed to isolate for the week. We have proof that he took vacation. What are my disciplinary options? Paul, this is a specific situation, and I think you have to contact us and we will advise you as to what your options might be. It certainly will depend on how you know this employee took vacation or not. There are a lot of moving factors here. So Paul, please contact us. We are happy to help you out as an employer as well. We do assist employers very, very commonly. So ensure that you contact us at employmentlawyer.ca or email us at help@employmentlawyer.ca. And we will ensure that we give you the information you're looking for. Okay, I'm gonna do one more question here from Mike. So Mike says, if the employer requires to get the shot in order to keep the job, I believe that means the COVID-19 vaccine, will this require him to pay 24/7, 365? So Mike, I believe you're asking, if your employer requires you to get the COVID-19 vaccine and you don't want to get it, then you do not have to. You would be owed a severance package in most cases. If you're being put on an unpaid leave or you were terminated as a result, you're going to be owed a severance package. And we have tons of resources on that very particular topic about COVID-19 vaccination issues and layoff issues as a result of COVID, Mike. So please check those out on our website at employmentlawyer.ca. And again, you can email us at help@employmentlawyer.ca. Check out our Pocket Employment Lawyer tool. It's a very, very useful tool. And that is it for today. We have another live stream session today at 1 p.m. Pacific time with my colleague Sandy Chen. We have another Q&A session at 10:30 a.m. Pacific time tomorrow, September 2nd, with my colleague Dan, and they are in Vancouver. And so we ensure that we have your questions answered in Ontario with myself and with other Ontario colleagues, and in BC as well. So I hope today was helpful, everybody, and I look forward to seeing you next time. Have a great day and enjoy the last long weekend of the summer. Take care.